session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1CACR170452, State of Arizona versus Crystal Eve LaPlante. Council, just a couple of reminders this morning. We'd remind you that we are recording this oral argument through both video and audio, so we'd please ask you to identify yourselves and who you represent at the beginning of your comments. Each of you will have 20 minutes. Appellant's counsel, if you're responsible to watch the clock and reserve as much time for rebuttal as you choose. And also, please keep in mind that we've read the briefs and have discussed this case in conference. With that, counsel for appellant, you may proceed.
May it please the court. My name is Carrie McConaughey Nolan. I'm here with my partner, Todd Nolan, from the Nolan Law Firm, on behalf of Crystal Eve LaPlante, who is present today in the courtroom behind me, Your Honors, along with family and friends who are here in her support. I will try to reserve a few moments of rebuttal, if possible. To start with, Your Honors, I would like to jump right into the third issue, unless there's someplace else that you would prefer for me to start. And in going into that, I would acknowledge right from the start that insufficiency of the evidence arguments are not generally the most popular or the most likely to be reversible error on appeal. We certainly recognize that. But in this particular case, like we stated in the reply brief, Your Honors, this isn't a situation where we're saying reweigh the credibility of the witnesses or reweigh the credibility of the evidence. What we're saying, Your Honors, is that there is a complete lack of probative evidence on several important aspects, in particular because this is actually a fairly complex statutory scheme regarding the vulnerable adult abuse statutes. So that starts with the vulnerable adult abuse, just the phrase vulnerable adult. In this particular case, the judge, it was tried to the bench, and Judge Kahn, I think, was trying very hard to make sure that he stayed within the statutory parameters and abided by what the rules require him to do. At the same time, he recognized that it was a complex situation, and in discussing the vulnerable adult situation, he specifically put on the record, and we quoted it in opening, and I think in the reply as well, his specific comments where he said, when it comes to whether they're vulnerable adults that we're talking about, nobody addressed that. There's not information or not argument about that. So I'm assuming that the parties must be conceding that, but it's just not clear, and I've thought about a lot, but there's just nothing about the vulnerable adult aspect here. And so the judge on that particular issue as a legal matter sounds as if he is abdicating his role as the finder of fact to find whether or not the first part of those elements for those crimes is met, and that is he didn't actually find that there was vulnerable adult here, the vulnerable adults, because he assumed that everyone was just assuming that was the case. And in our country and under our Constitution, that isn't the way that criminal trials are supposed to be held, Your Honors. Obviously, he has to find, as the fact finder, that in fact each element of the statutes is met, and the vulnerable adult part is one of those elements. So just starting from there, that could have been the end of the analysis. Look, there was no evidence of vulnerable adult abuse. His comments for a paragraph or a couple paragraphs where he talked about that, it could have ended right there at the Rule 20 motion and said, okay, because there isn't any evidence regarding this, I don't find this should all be immediately dismissed. Moving on from there, if you're willing to assume that these are vulnerable adults that we're talking about, if you believe that the law allows you to assume that and allowed the court to do that, moving on into the more complex aspect of the statutes.
Was there anything in the record that the judge could have used to find these victims were not vulnerable adults?
And I think that is a question that is somewhat up in the air, but when it's considered in the context of the rest of the statutes, I would say no. And that is because what we have here are assisted living facilities where it was never brought out throughout either, and it's discussed at length in the Rule 20 decision, and then also in the finding of guilt at the end as well, where there's lengthy discussion about it by the judge. It was never brought out the various aspects that you need to find that either. So for the vulnerable adult.
For example, what do you mean? For example, what aspects?
Sure. So if there's a great deal of testimony regarding the nursing assistants who came in and said, hey, one of the adults who are incontinent and their diaper needed to be changed immediately when I got there. A great deal of testimony about those kinds of things at the facility. But there is no basis to presume under the statute for what a vulnerable adult is, meaning that based on his mental or physical incapacities that he is unprotected, that he can't protect himself. Just because you're an adult who is incontinent and need help with your day-to-day activities in a residential type of facility, that doesn't necessarily establish per se that you're a vulnerable adult. Similarly, a more specific example as well, the resident who had a catheter, that isn't something that is commonly understood necessarily unless you've had someone or been in a situation where you know how the catheters work and such. But mere testimony, for example, that one of the residents who is ambulatory has a catheter and which necessarily has a bag that goes with it that drainage goes into, that doesn't also establish that he's a vulnerable adult in any way. That's something that is just a physical limitation that as we get older or for certain types of diseases you have to deal with, but it doesn't establish that, again, per se vulnerability, or there isn't something that tells you that that means he's in a state that he can't protect himself. And certainly for that particular patient, and I would point that out as well, or resident, he's the one in number 5, the fifth count in this case. The judge specifically talked about him and said, look, he's one of the other ones who has perhaps the least amount of evidence about him. And when they interviewed him in particular, he said there is no abuse, there is no neglect, there's nothing going on here that anyone needs to worry about. And he was someone, despite the fact that he had a catheter, he wore an adult diaper to protect him just in case, but at the same time he was able to go to the restroom himself for other purposes, and the catheter, the bag simply had to be emptied at certain times and such. But he was somebody who for the most part took care of himself, and who specifically they had quoted the state agents when they went in as saying, no, there isn't any kind of issue that you're talking about, all these things that are going on. I don't see any of that, and none of that has happened to me, and there's no problems with what's going on here. So again, it's there needed to be something to indicate, and so pushing forward with that, something to indicate what the standard of care is that we're talking about in relation to not just whether they're vulnerable adults, but the entire statutory scheme itself. This isn't simply someone who out in the world we're looking at whether it's a reasonable person standard. This is a very specific circumstance, and the reckless statute as well as the abuse statute, the 133623, both contemplate that what we're talking about is a gross deviation from the standard of care in the specific circumstance. So I would say that there was certainly a duty there for the state to present some evidence of what the standard of care is. How do we get to any lay juror, and in this case it's the judge who's the fact finder, but how do we get to a place where that person can establish, yes, in fact, I've seen enough evidence to conclude that these were vulnerable adults, and that also there was a standard of care that was grossly deviated from, and that deviation was done recklessly, and that it was done recklessly, and that it therefore could have caused this endangerment to any of these residents who were there. Those are all legal conclusions that simply could not have been made here because the evidence wasn't presented to help the fact finder to determine whether or not that happened. And again, when it comes to the vulnerable adult part, as well as when we're talking about, this also goes back to the first issue where we're talking about the notice and the time frame that was charged in the indictment. There wasn't enough information given for the judge to decide that. And on that one, he also pointed out, look, these dates must have some meaning, but there doesn't appear to be any meaning given the evidence that we've heard. So I'm just going to move on past that and go to the next thing. So that's not the way it works.
On the indictment, wasn't that waived?
I'm sorry, Your Honor.
Wasn't the indictment issue, I mean, the vagueness of the indictment, allegation wasn't that clearly waived by your client?
Your Honor, and initially, we agree that fundamental error review may be the appropriate standard for that.
But what isn't that State versus Anderson and some of the other case law, doesn't that say not necessarily fundamental error, but just waiver? You deprived the court of the opportunity to address that, it's waived, period.
It does say, those do indicate that, and that is the state of law generally as well, Your Honor, but here, the trial court did address it. So I would also argue, as we did in the reply, that perhaps there's still the argument that even though it wasn't specifically raised by the defense attorney at trial, it was addressed by the trial court. So the trial court wasn't completely deprived of the opportunity to review it, so perhaps a lesser standard would be appropriate here. And there's also the constitutional components where the constitutional issues can be reviewed de novo even. So we would argue, and again, recognizing that fundamental error may in fact be the appropriate standard, but here the judge did in fact address it. So we do have a record that this court can review and base a further ruling on, whereas in most instances of waiver, you don't have that. And I'd also like to point out for that one as well, Your Honors, this simply isn't a strict Rule 13.5 waiver issue where a defense attorney could have filed a motion to have a more specific indictment filed. This is a situation where the evidence never comported, never changed what was in the indictment, as the court recognized later. He just didn't have the information on some of these issues, like when this all happened. Why are these time frames so lengthy, or why were these time frames picked? And that is in asserting, like those cases of Anderson, the murder cases, where the state comes back and says, well, she just denied generally, so it's perfectly fine that she didn't have more specific notice. In a murder case, in those specific cases that the state is citing, all that was missing was the name of the victim. But we certainly knew there's a victim, here's when the victim died, we know that it's unnatural causes, so that it's a homicide, all of those kinds of things. Here, there's not even any kind of way you can assume there's an unnatural death or something that causes this to be even suspect of a crime to start with, so it's a little bit different. And on top of that, when we're talking about, for example, the ones with a 2-year time period for her to defend against, coming in and generally saying, for example, if it was a murder, I never killed anyone, is not going to satisfy a fact finder nearly as much as if you're able to come in and say, on this specific date and time that they're saying this person was murdered, I was in California, I couldn't have been the one who did it. Or on that particular date, all of my family was there, and so it was this third person who committed the offense as opposed to me. That's the reason the notice is so important, because you can make those kinds of assertions. Ms. LaPlante never had the chance to do that on most of the issues because it was such general testimony provided by these nursing assistants. And on that, in particular, I would note that the one count 3 that was dismissed, that was the one that had the most specific evidence, so that she was able to specifically address what was alleged against her. And in that case, the judge was able to say, yes, looking at what was presented and the actual facts that I have that support or don't support it, that means that it needs to be granted as a Rule 20 here. It would have been the same for the other things if there wasn't such general information where she couldn't necessarily provide enough of a specific defense to the claims. Just generally that, again, for example, that somebody's diapers aren't being changed in a timely manner. Well, how often do they have to be changed? Again, a lay person, I wouldn't expect to know that. And that's something that is a standard of care, that is an element the state needed to present to say, here's the standards that she was violating. Here's what her gross deviation was, is that you would expect this much care, this type of thing to be going on. And when you look at that lack in the record on top of the fact that what also was happening was you have the 3 state agencies who investigated this and multiple agents from those agencies, as well as the hospice doctor, hospice nurse, the chaplain, everyone else who was coming in to actually manage the care and take care of these various residents, saying there was no abuse. And again, the 3 state agencies who investigated it said there is no abuse, there is no neglect. It was unsubstantiated. So when you have that on top of the lack of any more specific evidence or specific findings by the court, because there just wasn't the evidence to support it, that means that this case should be reversed. And specifically, again, regarding looking at the specific evidence for each of the people, and the fact that when the police went in, when DHS went in, when Adult Protective Services went in, they all found that the claims were completely unsubstantiated.
But isn't it for the trier of fact in this case, the trial judge, to weigh what appears to be conflicting evidence. So you obviously cite the testimony of the APS investigators, but you have to acknowledge there was testimony from the hospice workers and former current employees that created conflict. So in that situation, it's for the trier of fact to determine the sufficiency of the evidence, not for this court.
Sure, and absolutely, Your Honor. I recognize that it is my opinion, and maybe as a defense attorney opinion, that the evidence so far outweighs what the state presented that I don't understand how anyone could have found guilt on any of the charges. I also recognize at the same time that, again, that isn't the best claim, except that we don't have the legal tools. He didn't have the information to provide him a basis to actually find it legally. So most importantly, like I said, the standard that she's supposed to be violating, that is a gross deviation that causes this to be a reckless violation of the vulnerable adult abuse statute, there is no standard presented whatsoever. So what is the standard that we can't just assume, and the judge couldn't assume it from thin air either? And I would like to read...
There are no regulations, administrative regulations that control what nursing homes should or should not do.
I'm sorry, Judge, would you repeat it?
Yes, are there no administrative regulations that control what
there are
should or shouldn't do?
Certainly there are, Your Honor, and that's one of the things when the state goes in and does their investigations, that's some of the things that they're looking for, and that's why...
Provide a framework as a matter of law, a standard of care.
Sure, but those weren't presented in this case, Your Honor, and that's part of the second issue that goes to the failure to present the reports from Adult Protective Services and United Healthcare potentially as well, although recognizing that as a separate entity that isn't as big of again, as good as a claim. But the Adult Protective Services issue is that they did in the end decide, wait, we want these people to come in and talk about their investigation, but they didn't bring in their reports. And again, that may have been waived earlier on, and there was confusion about whether they were going to argue that or how they were going to use that. But in just looking at the motions themselves, and for example, what United Healthcare filed in their motion when they were objecting, clearly they had involved in that their standards and practices and what it is that's supposed to be happening there. And certainly when Adult Protective Services goes in and looks at the certification for these places and whether they're following that and then decides whether they're going to substantiate or unsubstantiate something, that has to be part of their analysis, but it wasn't presented here. And that's why that's not something that falls to the defense on the defendant's burden in the sense of, well, couldn't she have just gone and gotten this? Couldn't the defense attorney just followed through and gotten it like he was supposed to? This falls into the class of this was part of the elements of the offense, in particular that they had to establish what the standard of care was before a judge or the fact finder can determine what a gross deviation from that standard is. I'm sorry, and at this point, unless you have other questions right now, I'll save the rest of my time for rebuttal. Thank you, Your Honors.
May it please the Court, Eric Nobla for the Arizona Attorney General's Office representing the state of Arizona. Much of appellant's arguments on appeal rest on speculation, but Arizona's courts have long held that speculation is not enough to sustain fundamental error on appeal. If we look at the first issue, the indictment, appellant speculates that she did not have notice. But in State v. Freeney, which appellant cites to, the court said that they can look beyond the indictment to see whether or not appellant had actual notice. And if we look at the only record the only evidence in the record shows that appellant had actual notice that the time frame was in between October and November of 2014. If we look specifically to appellant's own motion for the APS documents, she alleges that the APS investigation happened on November 2014. Also, if we look at the state's motion to compel the testimony, the state specifically says that they're looking at the time period of the investigation from October 2014 until April 2017, including the allegations that happened during that time frame. Third, if we look at what the witnesses that appellant was able to call in her defense, she was able to call witnesses that had visited the hospice during and around that time frame. Finally, we also look at the state's calling of Renisha, who testified that she began working again at that facility on October 20th, 2014, and that she immediately started to notice the deterioration of the conditions a few days after she began working. And there's nothing in the record to suggest that appellant was convicted for any of the acts outside of that time frame. But even if there was evidence, this court in State v. Self and State v. Jones, which the state cites in its answering brief, has said that dates are technical violations or technical errors that can be remedied by amendment. And specifically, appellant made the argument that the trial court discussed the time frame and that they didn't know where they got the specific timeline in the indictment. However, the court went further and said that they understand that the prosecutor probably was aware that this time frame would be amended to conform to the evidence at trial. And that's exactly what happened here. Lastly, on this issue, her all-or-nothing defense would not have been changed based on the timeline. So there's no prejudice here. She argued that she took these, her argument was that she took on these high-need patients that no other facilities would have taken on. And that although there were some issues, this was not because of any knowing abuse or recklessness, but because these were such high-need patients. And finally, she also, in her defense, was contending against the primary witnesses and the credibility of those primary witnesses, saying that they were biased against her and that they had lied. So this shows that the time frame was irrelevant to her defense. Now, if we turn quickly to issue 2, if the court has no further questions on issue 1, because we are under fundamental error analysis on the Brady violation, appellant has the affirmative burden to demonstrate that there was error. However, she has only speculated that the document was not disclosed. If the state had complied with the order and did not disclose that document, she had a duty to make that record down on appeal and say that the state did not comply with that court order. But the only evidence that she presents that the state did not comply or did not disclose that record was that the defendant did not use that document to refresh the recollection of one of the APS employees, Chris Villa. But there could have been a number of reasons as the defendant did not use that document. Second, she speculates that the document was material, and she speculates about what was contained in that document. But the only evidence she seemingly points to is that the complaints alleged by Angelique and Renisha, the primary witnesses, were that the findings were unsubstantiated, and that's what the document would show. However, this goes further to the prejudice in the fact that even if that evidence was in that document, it would have been cumulative based on the testimony that was presented by not only the APS employees, Erica and Chris, but also by appellant herself. And appellant testified that after the APS investigated, there was no follow-up. And the employees specifically testified that they had never saw anything that supported the allegations. So any evidence that, if we take her speculation as verifiable, then any evidence that would be presented in that record would have been cumulative to the testimony at trial. Finally, quickly turning to the issue 3 of the substantial evidence. Most of appellant's arguments here is complaining of conflicting evidence, but as this court recognized, those types of issues are for the fact finder, not a reviewing court. Here, there were multiple witnesses that testified about the conditions that the patients endured, and the photographs that were admitted as exhibits supported that testimony.
What about the argument here this morning that there was no framework provided in terms of definition of vulnerable adults, as to whether these victims qualified as vulnerable adults as to the applicability of the statute? And secondly, that there was no evidence presented on what the applicable standard of care was to be applied in this situation.
The court did make discussions about the vulnerable abuse, but the actual discussion was the fact that they didn't see any contention going against the fact that it was a vulnerable adult, and he essentially made the claim that the parties were conceding the issue that they were vulnerable adults. And if we look at there was actually evidence presented from both Renisha and Angelique that each individual was vulnerable adults, and the state actually fleshes that out in their answering brief, where they discuss that some of the patients were full assist, some of them were half assist, where they could actually get up and relieve themselves. And in fact, there was one patient that there was a two-person assist because they needed help using a Hoyer. And then they also had they also presented evidence that there were nursing assistants that discussed what would happen if they weren't provided the adequate care, and so that portion goes towards whether or not what was the standard of care. And I think Renisha and Angelique again testified that about the fact that these victims were that they needed that standard of care, and that if, for instance, in Richard or in one of the patients in one of the patient's cases, if that catheter had not continually been cleaned, there could be an infection that resulted. And in fact, one of the nursing assistants did find that catheter was not adequately cleaned at one point, and then there was an infection that seemed to be presenting. And also, I think it was either Angelique or Renisha that testified that they would need constant monitoring. I think every 2 hours they would need to see that whether or not the diapers needed to be changed. But they often found that they were not being changed. They would come onto their job and find that they needed to be changed at that moment. And in fact, in which the court put a lot of importance on, is the testimony that they would mark the diapers, and that for days after, when they would return, they would find that they would still be in that same diaper. And so the nursing assistants also, in their testimony, when they testified about what would happen if that standard of care was not followed, supported the evidence that when it wasn't followed, what could have occurred.
And was their standard of care testimony just based solely on their experience with this facility, or had they worked at other facilities? Or, I mean, there was no global expert, correct? I mean,
no, there was no global expert. But the witnesses that did testify, they testified in their capacity of knowing the conditions that the vulnerable adults were in, and also based on their experience as a nursing assistant or as a
training and education,
correct,
et cetera.
Correct. And so if
going back to the vulnerable adult definition briefly, and I'm reading I'm looking at the portion where the court said, I had the impression that everyone is conceding that issue, when he says that I didn't really give a whole lot of thought to whether any of these people or all of them were vulnerable adults. Do you recall from the transcript, did defense counsel object and say, no, that's not correct, Your Honor, we are vigorously objecting and saying there hasn't been no evidence whatsoever presented as to whether these the victims are vulnerable adults?
From my review of the record, I didn't see any objection. So if the court has no further questions, the state respectfully requests that this court affirm appellant's convictions and sentences.
Thank you.
Thank you.
Your Honors, just briefly, if I can touch on some of the things that may be of concern or that you're thinking about following the state's presentation. First of all, I would direct you, I believe it's to the record on appeal at number 58, and I apologize if that's incorrect, but it's the state's motion to compel that was filed prior to trial, where they wanted to admit the APS evidence in for their case. So at the end of that motion, Your Honor, the state says the state maintains this information is imperative to the criminal prosecution prosecution of the above defendant, and this order is required to comply with the requirements pursuant to 41-1959 regarding confidentiality and such. The state was conceding that, in fact, absolutely, the APS report, the APS information investigation was, in fact, critical to this particular case. So to then say later for the state on appeal to say that we're speculating or that there's some guessing about whether or not those things would have mattered, clearly they matter, especially where APS clearly, pursuant to the two witnesses who testified from APS, Mr. Villa and Ms. Carranza, that they had found no abuse. Certainly that is imperative to a case where abuse is what is alleged. Also, Your Honors, I would I would direct you once again back to the court's vulnerable adult discussion, and that was during the Rule 20 discussion where the court was saying there wasn't anything presented about this. So I would refresh the court about that it wasn't something that everybody was talking about through trial, or that the evidence somehow comported and established these things that the defense is now bringing up. That's not true. The judge was bringing this up during the Rule 20 and then even during the guilty verdict, where the judge is talking about the lack and the missing evidence and things that are there regarding, for example, the time frames and the vulnerable adult allegation. I would also like to read just one part of the 4/26/17 transcript where the judge is issuing the guilty verdict eventually, but in one part it's critical to this idea of the standard of care that we're talking about. What is it that Crystal is alleged to have violated? And the judge says that the issue I need to address isn't whether the defendant's facility was the worst in Havasu, was the best, etc., but whether or not whether she should have been charged or shouldn't have been charged. And if I stay here long enough and get to do more of these bench trials in every adult living facility in Lake Havasu, maybe I'll have a better understanding of how the facility compared to others. But that's not what this trial is about. The trial is about this defendant's behavior and whether it falls within the described statute. The problem is that I'm sorry, it's page 187. I apologize, Judge, on the 4/26 transcript. The problem with that is it's exactly right. The judge needs to know what he's comparing it to. He needs to know, he doesn't need evidence from all those other facilities like he's in the way he's talking about here, but he needs some standard to compare this to. The statutes require a gross deviation from the standard of care that a reasonable person in the circumstance would have engaged in, and there is absolutely no evidence to establish that, even though the state certainly had it. The APS workers, DHS, United Healthcare, if the state would have gotten those records, everybody who came in and testified and said these were unsubstantiated, even Lake Havasu Police, there were standards they're looking at to say that this abuse didn't happen, and the state didn't present that because then they wouldn't have had a case if they had. So for all those reasons, and I apologize for using up all my time, Your Honors, we would ask that you reverse, and as far as the substantial evidence goes, the proper thing is to enter a judgment of acquittal on the remaining 4 counts and release her from the penalties. Thank you, Your Honors.
Counsel, we thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. Stand adjourned.